I could have your attention, first of all, allow me to welcome the US Consulate General, Mr. David Hopper, who joins us tonight, and our various other distinguished guests, judges, academics, practitioners, and ladies and gentlemen. On behalf of the judges of the County Court, I welcome you to our court and to this particularly wonderful ceremonial court, where the former Chief Judge, Glenn Walden, presides over us in spirit at least. It's most important, in my view, that public courts are available from time to time to hear debate about matters of importance to the public, and this is such an occasion. I hope there will be many more. It's my duty now to do two things. One, to call upon Greg Reinhardt to introduce our guest, whose name is Diarmuid O'Scanlan. That's my attempt to be Irish. I wouldn't put too much weight on that. And secondly, to tell you that when all this is finished, there will be some entertainments in the form of food available outside, so don't go running away straight away. Come on, Greg.
Thank you very much, Chief Judge, Mr. Consul General, Your Honours, distinguished guests, ladies and gentlemen. This, I think, is the second occasion since the affiliation between Monash University and the AIJA in which we've jointly hosted a function such as this, and it gives me great pleasure to be associated with Monash and the AIJA to be associated with Monash in relation to these types of engagements. It's one of the things, I think, when we were looking at affiliation that we envisaged we would be able to do and to do very successfully. And it's testament to that, I think, that and to our speaker, that in fact we have a very large audience here on a Monday evening. So thank you very much for attending. Judge O'Scanlan was appointed a United States Circuit Judge for the Ninth Circuit by President Reagan on September the 26th of 1986. He received a JD degree in 1963 from Harvard Law School and a BA in 1957 from St John's University. He also earned the LLM Judicial Process degree at the University of Virginia Law School in 1992. He was awarded a Doctor of Laws honoris causa degree by the University of Notre Dame in 2002 and another honorary Doctor of Laws degree by Lewis and Clark College in 2003. As a judge on the United States Court of Appeal for the Ninth Circuit, Judge O'Scanlan has participated in over 4,000 federal cases and has written hundreds of published opinions on a broad range of subjects, including constitutional law, securities law, administrative law, and criminal law. His professional interests also include judicial administration and reform and continuing legal education. I have a very extensive CV in front of me, and I'm endeavouring to praise it and not to spend too much more time going through it, but it is a very extensive and meritorious CV. Between graduation from Harvard and investiture as a federal judge, Judge O'Scanlan was engaged in private law practice. And between 1969 and 1974, he was consecutively the Deputy Attorney General of Oregon, the Public Utility Commissioner of Oregon, and Director of the Oregon Department of Environmental Quality. A first-generation Irish-American, son of immigrant parents from Sligo and Derry, Judge O'Scanlan is married to the former Maura Nolan and has 8 children, very impressive. His chambers are in the Pioneer Courthouse in Portland, Oregon. Your Honour, it's a great delight to have you here. We look forward to everybody.
Well, thank you very, very much for that very generous introduction. You were very, very kind. I must say that this is a delightful experience for me. It is part of a program of the United States Department of State exchange of various people in different categories, and I am now completing the last event in Australia, having also spent an equal amount of time in New Zealand. So between Auckland, Wellington, and Christchurch, and Sydney, Canberra, and Melbourne, I feel as if I have a very good sense of this part of the world, and I must say it has been a great and wonderful pleasure to be the object of your hospitality and being among people who are interested in some of what's going on in the U.S. legal system, and for me to learn from you in terms of the kinds of issues that are most concerning you these days. And what's remarkable to me is that we find out that there's a great deal of overlap and a great deal of matching of priorities, and I'll be very happy when I get to that stage to take any questions that you might have on that. Now, we're going to be talking about some cases that arose out of September 11th, but I wanted to just say by way of preliminary remarks that it is amazing how September 11th has affected so many people in the United States, and I'm sure to an extent as well here in Australia. But remarkably, that event in downtown Manhattan, New York, occurred almost 3,000 miles away from where we live in Portland, Oregon, which is on the opposite coast. Yet 3 of our children had direct impact from that. Our oldest son, Sean, lost a classmate and a very, very good friend of his from college, who this young man was a bond trader on, I believe it was the 90th floor of the second building to collapse, and obviously didn't make it. Our son Brendan's wife has a first cousin, or had a first cousin, who was on the airplane that landed in Pennsylvania, and they found out later that he was able, by mobile phone, I guess you say here, his cell phone, to communicate with the ground, and that whole history has now been made available. And lastly, my daughter Annie, who lives in New York, was a volunteer and spent many evenings after work going down to the site to bring food and water and so forth to the firemen and the policemen who were involved in all of that. But above and beyond all of that, I just wanted to express the appreciation of this individual anyway, and our family, to the commitment that your country made in Afghanistan and continues to make. It is a great source of appreciation and support for us, because this whole issue is larger than any of us, and we'll be talking about it in some further detail. As you've heard from the introduction, the court I'm on is the United States Court of Appeals for the Ninth Circuit, just one level below the Supreme Court of the United States. It is the largest regional court in the country and encompasses 9 western states, including California, Oregon, Hawaii out in the Pacific, as well as the Western Pacific territories of Guam and the Northern Mariana Islands, and together comprises about 20% of the population of the country. And while I strive today well to represent my circuit, I must make explicit that I speak only for myself as an individual American judge, and not for the court of which I am a member. I'm going to be speaking with you today about 3 recent United States Supreme Court cases dealing with military justice and the extent of our Commander-in-Chief's powers in the times of war. Today, one of the most important and inescapable challenges we all now face is the very real threat of terrorism. Our respective countries have risen up in the face of such ignoble tactics, declaring a war on terror to protect our interests both home and abroad. And of course, this war is indeed a different kind of conflict, and it must be, for the threat it responds to is like none that we've ever encountered. But because the pernicious threat of terrorism is so very difficult to identify, much less to defeat, the precious value of information and intelligence in this struggle is difficult to deny. Nevertheless, a very fierce debate rages regarding the tactics used to glean it. For information is not costless. There is a price for it, whether paid in terms of money, loss of privacy, or even pressures on our cherished civil liberties. Striking a balance between the value and the cost of such information is inherently a political decision, and I mean that in the broadest possible sense. In democracies such as ours, the polity itself is the ultimate arbiter of this conflict. The way that people govern themselves in our systems, of course, is through elected representatives. Of particular note in this context is the president, the highest executive official, who is generally responsible for matters of national defense in the United States. In exercising such duties, the president's political decisions about how to respond to terrorism, indeed all of his political decisions, are bound by law, both statutory and constitutional. Tasked with determining the precise extent of those pre-existing boundaries is the judiciary, and most notably the Supreme Court. This court must finally answer whether the president exceeds his authority either under a statute enacted by the Congress or perhaps under the Constitution itself. Still, it is hard to deny the wide-ranging political and social ramifications these legal determinations can have. The U.S. Supreme Court's recent enemy combatant detention cases serve as excellent illustrations of these concepts. Now, as you may recall, after agents of the Al-Qaeda terror network launched attacks against the World Trade Center and the Pentagon on September 11, 2001, the United States Congress authorized the president to use, and I'll quote from the statute, to use, quote, all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks, or harbored such organizations or persons, end of quote. Pursuant to this statute, President George W. Bush sent the United States Armed Forces into Afghanistan to confront Al-Qaeda operatives and the Taliban regime that had supported them. During the ensuing hostilities, American forces captured a number of prisoners. Several hundred of them, including 2 British citizens, 2 Australian citizens, of whom you are very much aware, and several Kuwaitis, were subsequently transferred to the United States Naval Base at Guantanamo Bay on the southeast coast of Cuba. One of the men captured in Afghanistan, however, was an American citizen named Yasser Hamdi. Rather than being sent to Guantanamo, he was transferred to a naval brig in South Carolina. And a final person, Jose Padilla, also an American citizen, was not captured abroad at all. Rather, he was suspected of conspiring to transport and to detonate a so-called dirty bomb in America. Padilla was initially detained in a jail in New York, but was eventually transferred to military custody in the same area where Hamdi was being held. One thing, however, united all these people. The president had designated each of them as an enemy combatant, as a result of which they would not be subject to certain Geneva Convention protections available to those who can be classified as prisoners of war. Inevitably, many disagreed with this decision, arguing not only that the various detentions were poor political decisions, but that they were illegal ones as well. As one might expect, the legal challenges to the various detentions were subtle and multifaceted, and often entirely unrelated to questions regarding the political wisdom of President Bush's decisions. With such arguments in hand, next friends, or legal proxies, of some of the prisoners brought their dispute to the federal courts. The particular arguments and their resolutions by the Supreme Court differed in these three cases, and so I'll briefly discuss each of them individually in turn. The first case, Rumsfeld versus Padilla, Rumsfeld being the Secretary of Defense, involved the American citizen who was captured at Chicago's O'Hare Airport upon arrival on an airplane flight on suspicion of conspiring to obtain and to detonate a dirty bomb. But as is often the case in the law, there was a threshold issue. Before deciding what process, if any, Padilla may be due, and whether the president's actions were supported by the Constitution and laws, the trial court first had to determine whether it possessed the jurisdictional power to consider the case in the first place. The precise vessel for such jurisdiction is known as the writ of habeas corpus, a term well known to you as well through the common law. And of course, the writ was established in English common law several centuries before either of our two countries were even founded. And the great writ has historically served as the means by which a United States court examines the legality of an executive detention. In practice, the petitioner names his or her immediate custodian as the respondent. And this is because the court, by granting the petition, formally orders that that custodian set the prisoner free. For jurisdictional purposes, then, a prisoner seeking habeas relief must file his or her petition with the trial court that is in the same district as the custodian. The question in Padilla's case was who properly qualified as his immediate custodian, and based on where that person was located, which trial court had jurisdiction to hear the case. Here, Padilla's habeas petition was filed in New York because his counsel thought he was still being held there. But that turned out not to be the case. Rather, 2 days before Padilla's attorney filed the petition, the government transferred him to military custody in a naval prison several hundred miles away, in an entirely different judicial district than the one in which the habeas petition had been filed. Nevertheless, the New York Federal Trial Court, and eventually the Federal Appellate Court, the U.S. Court of Appeals for the Second Circuit, a sister court to mine, concluded that even though Padilla's custodian was not actually located in their district, he had sufficient contacts there to justify jurisdiction. The U.S. Supreme Court granted review and disagreed. Such a theory, the court noted, would undermine the rule that strictly limits the jurisdiction in which a habeas petition must be filed. For there are often at least some contacts between a prisoner's custodian and any given judicial forum. Accordingly, the Supreme Court dismissed the case. Padilla should be able to file a petition for writ of habeas corpus in another district, just not the U.S. District Court for the Southern District of New York. In Padilla's case, then, the court never even got past the threshold issue it first had to confront. The next case, Rasul versus Bush, involved the non-U.S. citizen Guantanamo Bay detainees. Just as in Padilla, this case presented a similar threshold question of whether the trial court possessed habeas corpus jurisdiction over the case. The very specific legal issue was whether a United States court, this one sitting in Washington, D.C., had jurisdiction to consider the claims of foreign nationals at a military base in the foreign country of Cuba. The district court, relying on Johnson versus Eisenträger, a U.S. Supreme Court case involving German prisoners of war during World War II, dismissed the action, holding that its habeas jurisdiction did not extend to foreign prisoners held on foreign soil, even if their custodian was within the boundaries of the court's judicial district. A federal appeals court, this time the U.S. Court of Appeals for the District of Columbia, again a sister circuit, agreed. The Supreme Court granted review and began its analysis by examining the Guantanamo Bay lease agreement signed some time ago between the United States and Cuba. While the lease explicitly does not establish ultimate sovereignty over the lands it specifies, it does provide that the United States exercises complete jurisdiction and control over them. Given such dominion over the specified land, the court determined that the military base was sufficiently within the territorial jurisdiction of the United States. And because the trial court and the prisoners' custodians were each located in the District of Columbia, Washington, the Supreme Court held that the habeas corpus statute indeed conferred jurisdiction over the case. Unlike Mr. Padilla, Mr. Rasul and his fellow petitioners were able to clear the initial jurisdictional hurdle in their case. The Supreme Court, however, was not. Because the lower courts dismissed the case, those courts never had a chance to consider the myriad of other claims presented in the habeas corpus petitions. And as a result, the Supreme Court simply sent those remaining issues back to be determined in the first instance by the trial court. Now, the final case, Hamdi versus Rumsfeld, is the only one in which the Supreme Court actually got beyond the threshold issue, although not by much. First, there were no jurisdictional problems with Hamdi's habeas corpus petition. Both he and his immediate custodian were clearly located in the United States and within the judicial district where the petition was filed. Accordingly, the Supreme Court was able to address some of the meatier issues involved. Yet Hamdi is nevertheless a complicated case, particularly because no single justice's view was able to command a majority of the court. So while there are close to 40 pages worth of legal opinions out of the Supreme Court of the United States, none of them can be characterized as the clear law of the land. The closest we have is a plurality opinion joined by 4 of the 9 justices. Still, a majority of the justices were able to find common ground on some points. For example, at least 5 of them agreed that the president had the statutory authority to have Hamdi detained by the military in the first place. Further, and perhaps most importantly, nearly all of the justices agreed that Hamdi deserved some kind of process through which he could challenge his designation as an enemy combatant before a neutral arbiter. But because of the fractured nature of the court's opinions, it is not at all clear exactly what kind or what amount of process would satisfy such a requirement. Some, such as Justices Scalia and Stevens, suggested that nothing short of a full criminal trial in a court of law would do, based on his status as a U.S. citizen. Others, including the plurality, indicated that the full due process protections of a trial in the United States courts may not be necessary. The Supreme Court ultimately remanded the case back to the lower courts, saving further consideration for another day. Now, the Supreme Court announced these rather limited dispositions in all 3 cases, Padilla, Rasul, and Hamdi, on June 28th of this year. It immediately sparked a media frenzy, prompting screaming headlines around the world. Almost all of them emphasized the perceived political repercussions of the court's decisions, such as, quote, court deals blow to Bush on combatants, end of quote. And in one of the more inflammatory examples, quote, court defies White House with ruling on prisoners, end quote. Indeed, as might be expected, some reports were overtly partisan. Compare, for example, quote, Supreme Court issues troubling decisions on war on terrorism, end of quote, with due process victory, unquote. But despite all the hoopla, I feel confident in presuming that the great public appetite for the case was not premised upon an interest either in the proper physical location in which to file a writ of habeas corpus, or in the interpretation of a century-old real estate lease. Rather, I believe it is fair to conclude that the fervor arose because of the perceived political impact the cases necessarily had. Although the Supreme Court generally decided upon narrow and rather technical issues and reserved several specific issues for another day, the effect of the decisions was to provide some support for those who refuted one of the president's political responses to the war on terror. And perhaps the Supreme Court did refute the president, but only in the most oblique sense of the word. The president's legal position was that the courts lacked jurisdiction over any of these prisoners, and the Supreme Court did disagree on that point, foreclosing the prospect that the United States court simply had nothing whatsoever to do with these cases. Additionally, the court did assert, over the objections of the administration, that Hamdi, at least, deserved some amount of process before a neutral arbiter to challenge his detention. But to identify a winner or a loser is far too simplistic in my view. For the Supreme Court, indeed all courts, make pronouncements of law, not politics. Indeed, despite the case's disagreements with the president's position on certain grounds, the court simultaneously reaffirmed several of the president's other legal propositions. For example, the court accepted that the United States is pursuing a legally authorized armed conflict with Al-Qaeda and the Taliban in Afghanistan. It also recognized that both the United States and non-United States citizens can be enemy combatants, and that the president can capture and hold them indefinitely, without trial, during the pendency of a given conflict. What is perhaps most clear from the decisions is that the courts will have some continuing, though perhaps limited, role in reviewing such cases. But beyond that, a great deal remains to be settled, both as a legal and as a political matter. Indeed, such additional considerations are already underway. In the aftermath of these three detention decisions, the president began establishing military tribunals to consider some of the claims of the Guantanamo detainees. And the Secretary of Navy has already announced 14 decisions among the 31 detainee combatant status review boards convened since June 28th. All 14 upheld the enemy combatant designation after hearings before panels of military officers. Annual review tribunals are also planned. Additionally, several trial courts, now exercising their newly affirmed habeas corpus jurisdiction, are beginning to consider the substantive question of just how much process the detainees must receive, and whether it may differ between those captured abroad and those seized within the United States, and between those who are American citizens and between those who are not. Of course, these are distinct from the military commission of 5 officers which will try David Hicks and 3 others on specific charges which have been filed, with the initial appearance having just taken place in the last few days, as you are very well aware. There is a fair chance that these and other legal questions will wind their way through our entire legal system once again, facing further review in the Supreme Court. And as we have seen, even the most obscure legal determinations the court may be faced with, such as the niceties of a 100-year-old lease, can implicate some of the most delicate political choices a free society must make in dangerous times. For this reason, I expect that the full attention of our country, and no doubt yours, will focus with profound intensity on our court system as we continue working through these difficult and important issues regarding military justice. I thank you for your kind and generous attention, and I welcome any questions you may have, either on the matters I covered or on any other subject which I can answer. Thank you very much. Questions? Yes, right here.
Well, I go back to the first of the three cases you
Sure.
discussed. I'm interested to hear the difficulty you encountered because the claimant in that case, or the plaintiff or any law, was not within the jurisdiction of the court to which he applied. I don't know whether special considerations operate because of habeas corpus, but don't you have any procedures or protocols in the United States for either transferring the case to the appropriate jurisdiction without having to start a new case, or for the court in which the case has commenced to assume a referred jurisdiction on behalf of the court where it should have been commenced?
Well, we certainly do have very broad powers to transfer cases in civil matters generally. But apparently, the habeas corpus jurisdiction is considered to be very narrow and very specific. Now, this individual will no doubt have refiled. In fact, I have no reason to doubt it might not have already been refiled in the proper district, which I assume is the District of South Carolina, where this naval prison is. Typically, habeas corpus cases put in issue whether the custodian, who has to be within the jurisdiction of the court, as properly holding the individual who is also in the same jurisdiction. I can only assume that because it was dismissed rather than transferred, that the Supreme Court is interpreting habeas jurisdiction in a very narrow sense. But as a practical matter, I don't think it's going to make any difference because this case will be refiled if it hasn't already been refiled. Yes, over here.
You mentioned that the courts have said that there should be some form of process, some form of due process.
Yes, yes, yes.
Going too far as to what that is. I wonder, is there any general guidance independent as to what that process or how far that process might go? And certainly you made mention on a number of youthful referees, somebody who will make a decision. Has there been any guidance as to whether those people will be found within the existing judicial system in the US, or will they be some other organ? Some of us in the room here would perhaps share the view that military officers may not necessarily be judicial referees.
True, true, true. There are two cases that are sort of in the background here that we need to talk about. One is ex parte query, which arose out of World War II and involved the trial of German agents who had infiltrated, I believe, the Florida coast by submarine and were found and tried by a military commission. And their counsel managed to get the case all the way up to the Supreme Court of the United States. And the Supreme Court held that the military commission did have jurisdiction and constitutionally could try these individuals. Now, keep in mind, there was a number of circumstances. First, this was in time of war. And I think the specific issue of whether the effort in Afghanistan technically qualifies as time of war will be litigated in due course. That has not been decided yet. And then secondly, these were foreign nationals and were not found in uniform. They were treated as spies. So there is that precedent that does give the military tribunal very, very broad power. Now, the second question is what form of due process? Reading the tea leaves, that is the separate opinions from the various justices, it would be quite probable that the American citizens are going to be treated in a certain, would be treated in a different category, notwithstanding that they can be also designated enemy combatants. But the two American citizens are in fact on American soil, not in Guantanamo. The fundamental question will be to what extent the comments made by Justice O'Connor will play out here. The inference in her separate opinion was that it could very well be that as to non-American citizens found overseas, notwithstanding the fact they are in Guantanamo, which at least has that much, as a result of these cases, that much status, that a military tribunal will satisfy the due process guarantees of the U.S. Constitution. Well, now, that has not been decided, but at least the inference from her observations would be such that at least there's some support for that notion. That's just one of, as you could see, numerous issues that are going to play out. I think we're going to be dealing with this issue for many years, actually. And the most interesting issue, I think, will be when will hostilities have ceased such that the right of the president to hold these detainees will have expired, in which case they would have to be sent back to Afghanistan. But that, in due course, I have no doubt that very inventive counsel will find a way to get those issues into federal courts eventually to be resolved. Yes, Raymond?
Can I go to far end of the process?
Sure.
That is there any likelihood that any of these matters are ultimately have an impact on the question of the death penalty in terms of the situation in America? Because it's obviously a very controversial area within your jurisdiction. Is there any likelihood that it will have any impact at all in that area?
Well, I don't think the death penalty is in play at this point. It's simply detention so far as all of the uncharged enemy combatants are concerned. Now, I can't speak specifically to the 4 individuals who have been charged. If they have indeed been charged with a capital offense, and there are very, very few federal capital offenses, extremely few. And I just can't say whether this is in that category or not. But it wouldn't. The death penalty is primarily a creature of state government, state legislatures. And, we have about of the 9 states that we have in our jurisdiction, only 4 states have it. So it's a matter of purely state law, and that doesn't play. It doesn't affect this issue. Yes, far back.
Have some or all of the detainees have been charged with
understanding is that only 4 have been actually charged, and those are the 4 that are before the military commission. The others simply are being held under the powers that the president has in conducting the defense of the country to detain enemy combatants found overseas and held overseas. That's as far as that has gone. It could very well be that additional people in Guantanamo will be actually charged with specific offenses, but I don't think that's happened yet. Except for,
Have been charged? Were they existing offences or?
oh Lordy, I'm not sure I can answer that question. I just don't know. The actual offenses were published in your newspaper just the other day. They were listed. And I can't answer that question. I just don't know. I'm sorry. Yes?
On the question about the death penalty.
Yeah.
My understanding from reading the newspapers is that Australia, through its discussions with the United States,
Mhm.
had agreed to our nationals being charged on the basis that there was an undertaking that there wouldn't be a death penalty imposed, whether or not it was allowed in the legislation. I think that's what Mr. Dennis is referring to, isn't it? Are you not aware of that?
No, I'm just not aware of what those arrangements are. I'm reluctant to guess, but I have not been informed that the charges against the 4 individuals carry the death penalty. I'm not informed that that is the case at all.
I think the more important issue is whether the understanding is that even if they do, it will not be exercised.
Well, unfortunately, I'm not in a position to comment on that. That would.
In your newspapers, it has been in our newspapers.
I see. I'm just not in a position to comment on that. I'm sorry. That's diplomatic issues, not legal. Yes, far back corner.
Going back to the point of indefinite detention pending
Mm-hmm.
the cessation of hostilities or war in a country, did the US Supreme Court discuss that point further other than upholding the executive's right, or did it simply stop there, given this is a very different conflict to traditional war, where it seems here that the executive has the power to constantly redefine what the war on terror is, as opposed to a traditional war.
Right. The Supreme Court did not define the contours, simply recognized the principle. And as I indicated just a few minutes ago, I would expect that that precise issue is going to be raised sometime. In other words, when can it be said that hostilities as such have terminated? Because the president's right to hold these detainees is dependent upon there being a state of war and hostilities still being ongoing. I'm sure that someone will raise precisely that issue in one of these fora, probably sooner than later. Yes? Oh, over here.
I don't want to presume to take the position of the Chief Judge. I just wanted to ask a question. You mentioned in your address that the courts are concerned with the law and not politics.
Yes.
But certainly courts often are asked to consider matters of policy.
Oh, yeah.
And given that the war on terrorism, whilst it has been to an extent considered passed by Congress in terms of law, it is a very law. And it certainly is, there are certainly large matters of policy that are being considered apart from the specifics of the law. Are you able to make a comment in relation to what extent the court may look at matters of policy, given that these are very much fast-moving issues?
Well, the court is acting on the representation, the recital, that as indicated in that statute that I read you a little piece of, there is a state of war sufficient to justify the detention of people that would be classified as enemy combatants. real question will, the specific question of whether there is a state of war or not was simply assumed. I don't know that that has been specifically tested, but I can guarantee you that someone will raise the question as to whether it has at some point come to an end. I think you just have to sort of watch the reports, watch the news as well. Yes,
I just wondered, the assumption was that there was a state of war at the time, why these people aren't accorded rights as prisoners of war and have access to all the various agencies that all the prisoners of war do have access to.
well, the precise answer to that, as far as I'm aware, is that these are individuals who are not in uniform. They are not in the service of a nation as such that can be identified as a belligerent, and they simply fall in between the stools so far as the Geneva Convention is concerned. But the Geneva Convention provisions rather carefully define who qualifies as a prisoner of war, and most people seem to assume that these people are properly categorized as enemy combatants vis-a-vis prisoners of war. But the sort of the next step in the analysis, well, why not give them POW status in any event? Now that's probably more of a policy question rather than a legal question, but the technical legal question at the moment at least, this is ongoing, but at the moment is there is a clear distinction between the two, and at least for the time being, people in this category are properly, assuming they are on the facts, found to be enemy combatants, will be separately categorized as that rather than prisoners of war. Yes?
Assuming an adverse decision at the tribunal level, what are the limits to the right of judicial review of those tribunal decisions?
Well, there are levels of review within the military system, and eventually it will get to a civilian court, which is the Court of Military Appeals Court of Appeals for the Armed Forces, which is a civilian court. I think most people are assuming it'll come up that way, but don't forget, we're also talking about the writ of habeas corpus, which is a totally separate procedure which cuts across all of that. In fact, that's how these cases got in the federal courthouse in the first place.
Are there any other questions? I think then I'd ask Professor Crowe to
Thank you, Greg. It's my very great pleasure on behalf of the law school to thank Judge O'Scanlan this evening. No matter what one's politics are, it's quite clear to me that the relationship between the US Consulate General, Monash Law School, AIJA and the County Court is very much a coalition of the willing in this case, if not the very able as well. The presentation this evening was, as you say, in your country, very fine to be sure. It brings to us, I think, the very fine reality of the role of the courts in dealing with matters of global importance. I had occasion on last Friday to not stand where you're standing, but to give a presentation. The theme there was Karl Popper and his book, The Open Society and Its Enemies. And the issue for me was
do we destroy democracy in order to save it? And I think the kinds of issues that you're confronting and the Supreme Court are confronting are absolutely central to the nature of our democratic process. I'm not sure whether your court, possibly like Michael's court, is sometimes just a way station on the way to greater things, but it's quite clear that you will have to deal with these very, very important issues. And I think for Australians, the issue is crucial, and our newspapers are concerned not only with David Hicks, but I thought more broadly, perhaps from my point of view, the true test of the US courts is what will happen now in US democracy, is what will happen now in your courts. And certainly the issue of the fundamental constitutional protections, whether or not through the Constitution or through the process of justice, brings home the very, very basic truths and freedoms that the Constitution embodies: the right to a speedy trial, the right to know the charges against you, those very, very basic human rights. And I think whichever court is hearing these things, from my point of view, every day that a person is held unjustly is 24 hours where great pain has been inflicted, and the conditions under which people are being held ought to be borne in mind by the courts when these cases wind slowly and agonisingly through the courts. Let me conclude, Judge, by saying that while the war on terror might well be uncertain and ongoing, the war on error will never end. Thank you.